Members, folks, let's go ahead and let's get signed in. Welcome to Judiciary Full Committee this week. It's good to see everyone. Madam Clerk, if you open up the sign in there, be great. There it is. All right, members, it should be on your screen now. All right, looks like we're good. All right. Madam Clerk, if you'd take the roll, please.
Mr. Chair, you have 16 members present. You have a quorum.
All right, very good. All right, members, any personal orders or announcements before we start committee today? We got a packed house back there. Any personal announcements or personal orders? All right, seeing none, we've got a calendar. Members, and folks, we have a few things that have been requested to be either rolled to next year or taken off notice. The first item is item number 3, House Bill 1271. Sponsors ask that to be rolled to the second calendar of 2026. Any objection? All right, seeing none. That's House Bill 1271, item 3. Moving on, item 13, House Bill 1166. Sponsor of that bill asks that be taken off notice. Any objection? All right, seeing none. House Bill 1166 is off notice. Item 52, House Bill 478. Sponsors also asked for that to be taken off notice. Any objection? Members? All right, seeing none. House Bill 478 is off notice. And then moving down to item 65, House Bill 36. The sponsors also asked for that to be taken off notice. Any objection to that, members? All right, seeing none. House Bill 36 is off notice. And that brings us to our calendar for today. We're going to be jumping around a little bit. It's just that time of the year, but we are not going to jump past number 1, item 1, House Bill 1097 by Speaker Zachary. All right, you've got a motion in a second, sir, and I see House Amendment 6481. Is that something you'd like to move forward with, sir? All right, members, I got a motion. I got a second. Any objection to adopting House Amendment 6481? All right, seeing none, all those in favor of adopting House Amendment 6481 to House Bill 1097, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, sir, and you're recognized.
Thank you, Mr. Chairman and committee. Members, carrying this piece of legislation for Speaker Sexton. And what this bill does is it prevents local governments from enacting policies that conflict with Tennessee state law and our state constitution, ensuring consistency and the legal integrity across our state. The bill ensures accountability of state funds. It ensures accountability that state funds are not used for unlawful policies, reinforcing uniformity and responsible governance throughout our state. Rather than allowing these unconstitutional policies to stand until challenged by a lawsuit, we've taken a proactive measure here to identify them and rectify early. With that, I'll be glad to answer any questions.
Members, any questions for Speaker Zachary? All right, Representative Powell, you're recognized, and moving to you next. Representative Johnson.
Thank you. Question for the sponsor. Are you aware of any of these? Could you give us some examples of this actually being the case as it stands right now?
Speaker.
Thank you, Mr. Chairman. Yes, sir. Thank you, Representative Powell, for the question. The most recent being the steps Memphis took with the gun referendums they placed on their ballot. And as General Scarametti was quoted saying, these ballot questions are fraud on the voters of Memphis. They will not change state law. This is a futile stunt that wastes time and money when the city council should focus on ensuring existing laws are enforced. However, we respect the court's analysis of whether the vote should proceed and will not file an emergency appeal. This legislation would have allowed us to prevent that from happening.
Representative Powell.
Thank you. You mentioned in your remarks that there's currently this takes place through the courts. This can be challenged in court. Why do you think we should take away that ability to not have this go through the court system and instead just hand it over to the AG?
Speaker Zachary. You're recognized.
Thank you, Mr. Chairman. So if you look at Section 1 of the legislation, it gives the Attorney General and a reporter the ability, if something is brought to their attention, to move forward with an investigation of the violation of state law or the Constitution. And then the local government has 60 days to remedy that. And if it's remedied, then no additional action is taken. It is if that action is not remedied in 60 days, that's when an additional legal action will take place.
President Powell, answer your question.
I guess just a follow-up there. I mean, this seems like it's going to place a lot of burden on our local governments. If we truly believe, our local governments we're responsible for speaking directly to the people they represent, and all government is best if it's local. Why are we now giving this ability to the AG? Seems like this has been working fine for years. understand the situation in Memphis, but other situations, usually it goes through the court system as challenged. This seems to just create more burden and ability for the AG to go after local governments and create a presence of fear to actually challenge some of the laws that are put in place that they disagree with, and then that might actually end up going through the court system and being overturned. So I think it's a dangerous precedent, but I am against the bill, but happy to have you speak to that.
Speaker Zachary.
Thank you, Mr. Chairman. Representative, as long as the local government doesn't violate state law or constitution, there'll be no issue.
Very good. Representative Johnson, you're recognized.
Thank you. And with that example, nobody violated any law. And whether someone thinks that the public doesn't have a right to vote on something that they think is important because the AG doesn't think it's important, that seems problematic to me. And I have to agree that if there is something wrong, it can go to the courts. But giving the AG this ability, it seems like it's a huge overreach of our local governments.
And folks in the seating area back there, just please remember to be courteous to the person sitting behind you. If you hold up a sign, just kind of keep it down below your head, so that way the person behind you can see and understand what's going on in this committee. Speaker Zachary,
No comment, Chairman.
any comment? Any follow up, Representative Johnson?
No, I'm good. Thank you.
Very good. Representative Hardaway, you're next on the list.
Thank you, Chairman. And good afternoon, good morning to you, sponsor these committees. So on the idea of a ballot initiative for an action that the courts may determine later to be legal or constitutional or unconstitutional, is the withholding of funds done before the case is adjudicated or after there's final action? How does that work?
Speaker Zachary.
Thank you, Mr. Chairman. Good question, Representative Hardaway. Thank you for asking. So yes, that would be the withholding of funds would be after that legal process took place.
Representative Hardaway, does that answer your question?
Well, I want to be very clear on this. So after means after the final appeal at whatever the highest court is, I assume.
Speaker Zachary.
Thank you. That's my understanding. Yes, sir.
All right. And this would make ballot initiatives, the content of a ballot initiative that the voters, the citizens would have the opportunity to vote on, illegal?
Speaker Zachary.
Thank you, Mr. Chairman. No, Representative Hardaway, thank you for asking that. I was just giving an example based on a previous question of what local government action that may have been in violation of state law. Because again, those particular steps that Memphis has taken regarding the gun referendum, those votes would have gone against state law, would have had no impact. And so in that particular case, the Attorney General and the reporter would have worked with the city of Memphis before those initiatives ever even took place, creating confusion among voters, creating expense to the taxpayers, and that could have resolved that before we ever got to that point.
All right, just a short statement, Mr. Chairman.
All right, you're recognized.
And that is that my understanding of the initiative is that it provided the citizens of Memphis an opportunity to vote on if they wanted to pursue it. Not on whether it would become law or not, but whether it was worth going the extra step in coming to the legislature or going to the courts and fighting to make that local ordinance a law. And of course, my local folks understand how state law supersedes local law. But they also understand that anytime there's a dispute between governments, or government agencies or levels of government, that's what our courts are for. So I'm concerned about the letter of this law, but also the spirit of this law. So I'm going to have to vote no on it. But I thank you for engaging me.
Any follow up, Speaker Zachary?
No, sir. Thank you.
Very good. Leader Lambert, you're next on the list.
Move previous question.
All right, previous question been called. Members, seeing objection, all those in favor of previous question, say aye. Aye. Opposed, say no. Ayes have it. Previous question prevails. Members, we're going to be voting to send House Bill 1097 as amended to state and local. All those in favor vote yes. Opposed, vote no. Has there been a vote? Anybody want to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 4 noes, and 0 present not voting.
Very good. House Bill 1097 as amended is moving to state and local.
Thank you, Mr. Chair and Committee.
That brings us to item 2, House Bill 826 by Chairman Faison. Sir, you have a motion and a second. I'm looking at House Amendment 5320, sir.
Yes, sir. That is the amendment that writes the bill.
Members, any objection to adopting House Amendment 5320? Seeing none, all those in favor of adopting House Amendment 5320 to House Bill 826, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended, and you're recognized, sir.
Thank you, Mr. Chair. Committee, last year I passed a bill that dealt with parental rights. As that bill fleshed out, became law, we did identify some issues that we wanted to clarify. This bill makes some clarifications of the Family Rights and Responsibilities Act we passed last year based on discussion with parents, school personnel, and healthcare providers as it deals with emergency care and putting on Band-Aids and ice packs. Specifically, that clarifies that healthcare providers can separate and screen minors if they suspect trafficking, neglect, or abuse by a parent. And it's just a clarification bill.
Members, any questions for Chairman Faison? Seeing none, I got you. You're recognized, Representative Johnson.
Okay, I might have the wrong bill. Is this not the one that about 20 days? Okay, thank you.
Members, any additional questions? Any objection to the question? Seeing none, all those in favor of sending House Bill 826 as amended to calendar and rules, vote aye. Those opposed, vote no. Has everyone voted? Anybody like to change their vote? All right, Madam Clerk, you take the vote. Thank you.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Thank you, Chair, Committee.
Very good. House Bill 826 as amended is moving to calendar and rules. That brings us to, of course, item 3 has been rolled to the second calendar of 26. Item 4, Chairman Vaughn, sir. That's House Bill 797, members. And it looks like there's a couple of amendments on here. The latest looks like it's 6984. I got you. Members, that we may have to address the procedure.
I was going to say, Mr. Chairman, I do have 6984 was drafted with an error, and I have an untimely filed one, but I like to call it the all's well that ends well amendment. If I could get the body to consider 6919.
Very good. So members, we're going to be voting to. Okay. Chairman Vaughn, I've been told that.
Did I have it backwards? Okay,
yeah.
Never mind. Then
so members, we're going to need a motion to take up untimely filed House Amendment 6984. All right, got a motion and a second. Any objection to the question on that amendment? All right, seeing none. All those in favor of adopting House Amendment, untimely filed amendment, or 6984, say aye. Aye. Opposed, say no. Ayes have it. And now we're back on the bill as amended.
Yes.
And you're probably recognized.
Yes, sir. Chairman Farman, I'd like to say that I appreciate this committee's indulgence, but allowing parties to air their grievances in this. And I would have to say that some statesmanship, I appreciate, number one, Representative Davis's concern about this that she brought to me. And I'll just have to say that the statesmanship of Representative Tory Harris getting involved with this, we were able to get a deal brokered between those two parties. This amendment is the result of that. So these differences are going to be handled on the local level. They're in court. They're moving towards resolution, and we have a stopgap measure in there in case they don't continue this good work together. So that's what this bill does. And like I said, I appreciate the work of this committee.
Very good. Representative Towns, do you have your hand up, sir? All right. You're going to defer to Representative Hardaway. You're recognized then.
Thank you, sir. First, I want to thank the sponsor for giving a junior credit for what the senior members did, but we'll take that up in private, sir.
Back home.
But thank you for listening to the concerns of the juvenile court and at the same time, the concerns of the sheriff. And this compromise will work. I think it'll go well in advance of that October 1st date. And I'm not sure if you gave a full explanation of it, but at some point, if you would give an explanation of the whys behind it so that everyone knows what's going on. Thank you, Chairman.
Chairman Vaughn.
Yes, sir. Mr. Chairman, what happened was that the Shelby County Commission, at the request of the county mayor, has provided funding for the county. The county has a contract now to provide the transportation services that had fallen to the sheriff's deputy. So the juveniles will be transferred back to the juvenile court judge's new facilities, the ones that are not housed at the detention facility, but those who are coming in to be adjudicated, they'll have transportation back and forth, but it's just not provided by the sheriff's department anymore. Those resources can stay on the street, and the local government provided the funding to take care of that, and the situation hopefully is resolved. And sometimes it's a shame that we have to come up here to resolve disputes, but that's the way it happens. And like I said, it's one of those issues to where this was a bipartisan cooperation in governance exercise, and I think we've got it put away to where it needs to be.
Representative Towns, sir.
Mr. Chairman, thank you. And Chairman Vaughn, thank you as well. The beautiful thing is that we had an opportunity for full disclosure from both sides. After full disclosure, we really tried to point out they both had needs that need to be met. And as you indicated a moment ago, the wisdom of the body, we saw that, and we were able to accommodate that, which, is what I think we should have done, and we did it. And hopefully the solution that we come up with will work perfectly. And if not, we'd have to come back and tweak it. But they both were in dire need, and it boils down to safety and being able to be efficient. So I appreciate it. Okay, good work. Thank you, sir. Mr. Chairman.
Yeah, it's certainly good seeing members working together across the aisle. It's refreshing. Leader Lambert, you recognize.
Move previous question.
Members' previous question has been called. Any objection? All right, seeing none, members were voting to send House Bill 797 as amended to calendar and rules. All in favor, vote aye. Those opposed, vote no. Has anyone been voting? Anybody want to change their vote? All right, Madam Clerk, if you take the vote.
Mr. Chair, you have 16 ayes, 0 noes, and 1 present not voting.
Very good. House Bill 797 as amended moves to calendar and rules. Congratulations, sir.
Thank you, Mr. Chairman and committee.
Very good. And folks, we're going to move down one item. We're going to move down to item 6. That's House Bill 190 by Representative Gant. Sir, if you'd like to go ahead and you've got a motion in a second. I don't see any amendments on your bill. If you go ahead and let us know what it does, and we'll.
I'm sorry, which bill? I've got 2.
It's item number 6, House Bill 190. 190.
Okay, great. Okay, Chairman, committee, thank you.
I'll do that too.
What this legislation does is it's on behalf of the District Attorney's Conference. And currently a person commits aggravated vehicular assault if the person commits vehicular assault and has a blood alcohol content of 0.20 or more at the time of the offense and has 1 prior conviction for a DUI or a BUI. A person commits aggravated vehicular homicide if the person commits vehicular homicide and has a blood alcohol content of 0.20 or more at the time of the offense and has 1 prior conviction for DUI, BUI, or a vehicular assault in this scenario. And this bill simply lowers the enhanced blood alcohol content for aggravated vehicular homicide and aggravated vehicular assault from 0.20 to 0.15. Lowering the enhanced blood alcohol content holds individuals accountable for driving with significantly impaired judgment and motor skills. It sends a very strong message that being twice the legal limit will have serious legal consequences. And Mr. Chairman, I know we're all in a hurry and I can go on if the committee would like me to, but I'll try to be as brief as I can. So be respectful of the committee's time. So
thank you, sir.
Stand for questions.
Members, any questions for Representative Gant? I don't see any. Any objection to the question? All right, members, looks like we're ready to vote to send House Bill 190 to Finance, Ways and Means. All those in favor vote aye. Opposed, vote no. Has every member voted? Anybody want to change their vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
All right, House Bill 190 moves to Finance, Ways and Means. Sir, and I believe you have one more on the calendar as well, members.
Yeah, if you would
Without
allow me,
objection,
that'd be great.
if we could move to item 28, members, item 28. That's House Bill 904. You have a motion and a second. I'm looking at House Amendment 4350, sir.
Correct.
Members? You've got a motion and a second on House Amendment 4350. Do we want to go ahead and adopt that amendment, members? Any objection? All right, seeing none. All in favor of adopting House Amendment 4350 to House Bill 904, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're recognized.
Mr. Chairman and committee, this bill would give an administrative judge another option to consider when trying to determine if a person is owed attorney's fees from a contested case hearing involving the Alcohol Beverage Commission, known as the ABC. The bill would allow the judge to award fees if the person prevails in administrative action brought against the person by the commission and the fees cost incurred as a result of the administrative action.
Thank you. Members, any questions for Representative Gant? I don't see any. Any objections to the question? All right, looks like we're ready to vote to send House Bill 904 as amended to calendar and rules. All those in favor vote aye. Opposed, vote no. Has everyone voted? Anybody want to change their vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Item 28, House Bill 904 as amended is moving to calendar and rules. Thank you, sir.
Chairman, thank you. Committee,
Appreciate
thank you.
All right, members, if you would just continue to indulge me on this, I'm going to move down also to take item, if we could, without objection, item 27, House Bill 696 by Representative Gillespie. So you got a motion and a second there, and I'm looking at House Amendment 4438.
That is 4438, correct, and
All
it
right.
makes the bill.
Members? I've got a motion and a second. Any objection to adopting that amendment? Members? All right, seeing none. All those in favor of adopting House Amendment 4438, House Bill 696, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and it's all yours.
Thank you, Mr. Chairman and committee members. I'm bringing this legislation on behalf of the Sexual Assault Center to establish a statewide START coordinator, sexual assault response team coordinator position. Last session, as you all know, Representative Davis and Senator Massey passed the START Act requiring START teams to operate in each local law enforcement division. What this is doing is establishing a dedicated person to oversee that role for all the training and compliance and any help they need. Right now, this is kind of a piecemeal across the state. Different people are doing different things, and this would try to unify it under one umbrella organization. I'm honored to work alongside these people that do this job every day. This bill accomplishes a lot, but we're not done yet. And with that, I welcome any questions. I also have Rachel Freeman here if y'all would like to ask questions to testify, if y'all need any more examples as to why that's needed or what this person will do. And with
Okay.
that, I renew my motion.
And I do have some folks here that's asked if we need to hear from them, we can. If not, members, it's up to the body. Question's been called on the bill. Any objection? All right, seeing none. Looks like we're ready to vote to send House Bill 696 as amended to Finance, Ways and Means. All those in favor vote aye. Those opposed vote no. Has everyone voted? Anybody like to change their vote? Madam Clerk, if you take the vote.
Mr. Chair, you have 17 ayes, 0 noes, and 0 present not voting.
All right, very good. Item 27, House Bill 696 as amended is moving to Finance, Ways and Means.
Thank you all so much.
Thank you. Excuse me. Members, if we could also out of order and without objection, if we can move to item 51. That's House Joint Resolution 147. Representative Haynes, Helton Haynes. Ma'am, and you've got a motion and a second there, so you're probably recognized.
Thank you, Mr. Chairman. HJR 147 is a resolution to the regulation of kratom. An estimated 1.7 million Americans aged 12 and older currently uses mitragynine or kratom to self-treat various medical conditions. Kratom mimics the opioids currently problematic for abuse, addiction, and lethal side effects, yet the substance can be legally purchased by adults in Tennessee. It is popularly referred to as gas station heroin. Kratom is sold in capsule, powder, and liquid extract form at convenience stores across the state and can often be found between the gum and drink selections. The myriad formulations of kratom have various concentrations and doses and are not accompanied by specific information about ingredients, purity, dosing association with various uses, drug interactions, or any warnings regarding the documented cases of overdose, which are hepatic liver failure and possible death. From 2021 to 2023, more than 2,000 fatal kratom-related overdoses were recorded from 40 reporting states and Washington, D.C., and reports of kratom-only fatal overdoses are now recorded by medical examiners. Kratom is promoted to have a wide range of benefits and very few side effects, but this herbal dietary supplement is actually banned in 2 nations where the native plant is grown. It is a controlled substance in at least 16 countries and is banned together in Germany, Australia, and Sweden. Several states are beginning to regulate the storage, distribution, and sale of kratom, while other states have outright banned it in any form. The states choosing to ban kratom have added the substance to their list of controlled substances as a scheduled drug to reflect its abuse, addiction potential, and reported side effects. The tragic consequences of the unregulated sale of this substance are demonstrated by the untimely death of Matthew Davenport, who died on March 18, 2024, from a lethal interaction between his doctor-prescribed medications and kratom. Matthew was a kind and thoughtful young man, and although he struggled with depression, anxiety, and alcohol addiction, he had found support in rehab and sober living home, where he had been thriving. It is indeed a tragedy that his life was cut short by a harmful yet unregulated substance that he purchased as easily as breath mints at a convenience store. Karen Davenport, his mother and a nurse practitioner, is now leading the fight to heavily regulate or outright ban the sale of kratom in Tennessee, to end such preventable tragedies and spare other parents, spouses, and children the unrelenting devastation of losing a loved one in such a senseless way. Tennessee has led the nation with its careful development of capped morphine prescriptions, a database to stop doctor shopping, and the closure of pill mills. Yet we still allow the sale of an unregulated compound that is promoted as all natural, effective, and safe, but in actuality is proving to be addictive and even deadly. Our families and communities deserve protection from harmful substances such as kratom. I ask that we support the strictest state regulation of kratom or even an outright ban on the sale of kratom in Tennessee.
Thank
Thank
you.
you,
And I have
Mr.
Leader
Chairman.
Landon on the list.
Thank you, Mr. Chairman. And Representative Haynes, thank you for bringing this. I mean, those of us been around a few years. I mean, there have been multiple attempts over the years to outlaw kratom for these very reasons. And I'm not calling out anybody or fussing anybody on how folks have voted in the past, but this is the result of us not outlawing these substances. I mean, it is a very dangerous substance, and to just buy it in a gas station is horrible public policy, in my opinion. It's powerful. It should be at the very least a controlled substance, and as you said, heavily regulated. But to just have it out there anywhere for anybody to be able to just grab up and use is very dangerous. And I deeply appreciate you fighting for your constituents and for highlighting the grief that this family is going through every single day, because we've not made a decision down here on this that would help protect Tennesseans. So I really appreciate your efforts here, and I know this means a lot to you. So thank you for bringing it. I know it's just a resolution, but it is an excellent step in the right direction.
And thank you, Leader.
And Representative,
Mr. Chairman, with your permission, I do have Karen Davenport here, and I'd like to go out of session and hear from her.
very good.
if possible.
I looked down to just noticed that, and that's my fault. Members, any objection going out of session, hearing from Ms. Davenport? All right, seeing none. And thank you, Ms. Davenport, for being here. If you just have a seat there, your light will come on like it is on my microphone when you're ready to talk there. And then today we got the rules changed just a little bit. Typically we give 3 minutes. Today it's going to be 2 because we just have a massive amount of testimony throughout this committee on this. And I just want to give everybody an opportunity to be heard. So
Thank you.
whenever you're ready, you've got 2 minutes, and then we'll have time for questions.
My name is Karen Davenport. I'm a wife and a grandmother, a nurse practitioner in Chattanooga. I'm also a grieving mother who once gave birth to 3 children. But on March 18th of 2024, my world was shattered when my son Matthew, one of my twins, died suddenly in his sleep. The cause of death was the lethal interaction of the doctor-prescribed medication, Buspar, duloxetine, Benadryl, and an unregulated substance called kratom. Until that tragic day, I never knew of kratom, never heard of it before. Matthew was living proof that a person could regain their footing with proper care. He had suffered with anxiety and depression and alcohol, and he was in a sober living facility. Tragically, that stability was cut short when kratom, purchased as casually as breath mints at a nearby convenience store, played a fatal role in his death. I cannot adequately describe the heartbreak of losing a child. My husband and I watched helplessly as our doctors tried to revive our son, only to hear the hollow words, "We're so sorry, we tried everything." In that surreal upside-down moment, I remember screaming his name and clutching his lifeless body, still unable to believe that we had just had dinner the night before. Since March 18th, I've struggled with birthdays, holidays, everyday life without Matthew. My family has been robbed of our joy. My grandson will never again see his uncle light up a room with his quiet humor. And Matthew's twin sister, who once shared every milestone with him, will forever feel his absence like a missing piece of her own soul. Matthew's toxicology report confirmed the interaction between the prescription medications for anxiety and depression and kratom was a lethal Kratom is marketed as a benign substance for stress and pain, but it binds to the opioid receptors and it remains unregulated, readily available in gas stations and convenience stores. It's been linked with numerous deaths in the United States and around the world, and now rehab centers are starting to admit patients struggling to get off this substance. As an ongoing mission to warn others, I speak to youth groups surround sharing Matthew's story to illustrate the real and devastating risk of kratom. I'm also reaching out to you to provide legislative support because no human trials exist to establish safety, efficacy, dosing information, side effects, or drug interactions, nor any medical benefit.
All right, members, do we have any questions for Ms. Davenport? I'll let you go a little past that 2 minutes. It's very important for us to hear what you had to say there, ma'am.
Yes,
Leader
sir.
Lambert, sir, you're recognized.
Ma'am, I know you had a little more there that you wanted to share. I would ask what else you wanted to share. I'd like to hear a little bit more. And I know, Mr. Chairman, we got a lot today, but I can't imagine anything more important than listening to this mother here to share just a little bit more. If we can just let her go in a few minutes.
Ms. Davenport, you're recognized.
Thank you, Chairman. As Dr. Scott Gottlieb of the FDA explained in February of 2016, the agency considers it an opioid and a chemical of concern. Newborn babies whose mothers have been exposed to kratom are now being treated with the same neonatal abstinence protocol of those mothers of fentanyl, OxyContin, and heroin. Numerous states, Alabama, Arkansas, Vermont, Indiana, Rhode Island, and Wisconsin have banned it. Also, two countries where the substance is actually produced, Indonesia and Thailand. I urge you to consider supporting legislation to schedule and ban kratom in the state of Tennessee. With your guidance, we can share an end to these preventable tragedies and spare other parents and spouses and children the unrelenting devastation of losing a loved one in such a senseless way. I humbly ask for your leadership. Our families and communities deserve protection from this harmful substance like kratom. Thank you for your time, compassion, and willingness to address this critical matter.
And thank you. Members, do we have any questions for our guests? All right, see, Representative Hardaway, you're recognized.
Thank you, Mr. Chairman. And I know the other members of the committee share my praise for you, ma'am, in coming forward, having the strength to lead this effort in some ways as a living, loving legacy for your son. So thank you, ma'am.
Thank you.
Members, anyone else? All right. Didn't look like anyone else, ma'am. And thank you so much for being here and sharing your the story of your son there. Thank you so much.
Thank you.
All right. Members, any objection going back into session? All right. All right, back in session. Representative Hilton Haynes, ma'am.
Thank you, Mr. Chairman. I just would appreciate everybody's vote on this HJR.
Very
Thank
good.
you.
Question's been called. Any objection to the question? All right, seeing none. Members, we're going to be voting to send House Joint Resolution 147 to calendar and rules. All those in favor vote aye. Those opposed vote no. Has that member voted? Does anyone like to change the vote?
Mr. Chair, you have 19 ayes, 0 noes, and 0 present voting.
Very good. Members, House Joint Resolution 147 is moving to calendar and rules.
Thank you, Mr. Chairman and committee.
You're welcome. And members, without objection, we can move to item 24. We have a couple members been sitting on the front row. We have Chairman Hurt. Sir? Members, that'll be item 24. House Bill 347. You got a motion in a second. Remember, we have members, I'm looking at House Amendment 5136. Sir, is that something you'd like to move forward with?
Yes, Mr. Chairman, that's what I have.
Members, well, I've got a motion in a second. Any objection to voting on House Amendment 5136? All right, seeing none, all those in favor of adopting House Amendment 5136 to House Bill 347, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. Sir, you're recognized.
Thank you, Mr. Chairman, committee. Members, this is House Bill 347 is Poverty is Not Neglect bill. And when we started this process, we had a 7 or 8 page bill, but working through subcommittee and working with stakeholders, we have narrowed this down now to what we think is sufficient for a good first step in addressing our concerns. And it is basically just 2 sections. And it just changes. It just says the economic disadvantage of a parent or guardian alone is not ground for termination of parental rights. And also in section 2, neglect does not exist solely on the basis of economic disadvantage. And that's simply what we're doing at this point, Mr. Chairman. I'll take any questions.
Members who have any questions for Chairman Hurt? Seeing none, we ready to vote? Any objections to the question? All right, members, we're going to be voting to send House Bill 347 as amended to calendar and rules. All those in favor vote aye. Opposed vote no. Has every member voted? Anyone like to change their vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 347 as amended moves to calendar and rules.
Thank you, Mr. Chairman and committee.
And members, we also have members, without objection, move to item number 29. I saw Representative Rutter. She is there. Very good. So that's House Bill 995, members. Then we have House Amendment 4233. Any objection to adopting that amendment, members? All right, seeing none. All those in favor of adopting House Amendment 4233 to House Bill 995, say aye. Aye. Opposed, say no. Ayes have it. Ma'am, you're probably recognized.
Thank you, Mr. Chairman. Amendment 4233 addresses alcohol-related immunity does not apply to the TBA ABC license and their employees while they're at work. That's what the amendment does. A couple of years ago, we passed legislation that gave a limited immunity protection to someone who in good faith called for emergency medical help if they thought a person was experiencing a drug overdose. House Bill 995 would extend those limited immunity protections to alcohol-related misdemeanor violations that appear in minors under the age of 21 who might be experiencing an alcohol-related overdose. This bill adds language to clarify that an overdose can be related to drugs and to alcohol. This bill aims to save the lives of young Tennesseans by reducing fear and increasing the likelihood that someone would make that call to 911 to help save a young person's life who might have overdosed on alcohol. That's the bill, and I stand ready for questions.
Great bill. Members, any questions for the sponsor? Question's been called. Any objection to the question? Seeing none. Members, looks like we're voting to send House Bill 995 to calendar as amended to calendar and rules. All those in favor, vote aye. Those opposed, vote no. Has there been a vote? Anybody like to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 20 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations. House Bill 995 as amended is moving to calendar and rules.
Thank you.
Thank you. Members, we can move back up the list. We have Chairman Crawford. Sir, item 22, House Bill 540. And I don't see any amendments, no testimony, sir. So if you would, just go ahead and let us know what your bill does, and we'll go from there.
Thank you, Mr. Chairman. Thank you, committee, and thank you, guests that's with us today. This particular bill, I will be very brief with. I'll just hit the highlights. This bill is supported by the Tennessee Sheriff's Association, also the National Sheriff's Association. What it does is it puts the animal fighting title into a RICO charge if you meet all the elements. We're trying to target more of the organizations that's doing this than the individuals that's participating. It also will change the penalties for animal. It will not change any of the penalties for animal fighting. For instance, cockfighting and all that stays the exact same. This bill does nothing to change that. Again, I explained about that you have to meet several different elements to be even considered to go into the RICO Act. Just another tool that we can use to curb organized crime. There is 70 different offenses that are listed under the RICO Act, and we're just asking that this be added to the RICO Act. And I'm pretty sure that there is, if anybody's interested, this particular bill has been passed in 10 different states. So it's working really good. The DAs are very happy with it. So that's what the bill does. Sorry for taking so long.
Oh, you're fine. Members, any questions for Chairman Crawford? Question's been called. The objection? Seeing none. Members, we're going to be voting to send House Bill 540 to Calendar and Rules. All those in favor, vote aye. Opposed, vote no. Any member ever voted? Anybody like to change the vote? Madam Clerk, will you take the vote?
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Well, congratulations, Mr. Chairman. House Bill 540 is moving to Calendar and Rules.
Thank you, Mr. Chairman. Thank you, committee.
Remember, we're going to be moving to, without objection, we're going to move down to item 31. Representative Mayberry, sir. You've been sitting there patiently. House Bill 524, members. You got a motion, second on it, sir. I don't see any amendments, and you're properly recognized.
Thank you, Mr. Chairman. This bill simply will authorize a defendant with veteran status in a certain criminal cases to file a motion to transfer the cases to a contiguous county. Specifically, in Montgomery County, we have a large veteran treatment court, and this bill will allow the surrounding counties to be able to come to us to treat them.
Very good. And I noticed you do have a gentleman that had signed up to speak. I don't know if members, we may not have any questions. Members, do we have any?
It's actually the judge who asked for this bill to be written. So if you would allow him, I would love.
Members, any objection going out of session hearing from Judge, excuse me.
King Goble.
Go. Okay, Goble. Okay, very good. Members, no, without objection, we'll go out of sessions. Your Honor. Sir, appreciate you being here. Your mic's on, and just if you could just keep it around 2 minutes there.
We'll try to keep it to less.
There you go. Thank you.
In Montgomery County, we have the largest veterans treatment court in the state, and one among the largest in the nation. And I'm of the opinion, I'm hopeful that you will consider allowing me to take jurisdiction for justice-involved veterans in the contiguous counties to come to Montgomery County if they choose to get treatment. We have a large contingent of service providers to include the VA, gives them the best opportunity for success. Our recidivism rate is roughly 10%, where the state recidivism rate is roughly 30%. So it saves money, it saves lives, and I appreciate your consideration.
Thank you, Your Honor. Members, any questions for our guest? Representative Hardaway, you recognized.
Thank you, Chairman. And good afternoon to you, and thank you for the work you do. Good morning to you, rather. So the counties that would be eligible are just the Stewart, Houston, Dixon, Cheatham, and Robertson, or are all of the 95 counties?
Just the contiguous counties. It wouldn't be practical for anybody further away to be able to participate in the means that we require. So it would just be those contiguous counties. We have also a standing agreement with Davidson County, and because soldiers from Fort Campbell sometimes go to Nashville and get in a little bit of trouble, Judge Blackburn and I have an agreement that they send people to our court as well.
Okay. And would Shelby County have the same type of operation you have? Should we be looking at something comparable?
Well, I think that's up to the judge. Obviously, I think you've got a new judge coming in as a Veterans Treatment Court judge. It's a voluntary court, it's not mandated. So ultimately, the judge that comes in would have to decide if he or she is willing to take on that extra burden.
All right. Thank you, Mr. Chairman. Thank you again. Thank you, sponsor.
Members, any additional questions for our guests? All right, seeing none, any objection, going back into session? All right, seeing none. Thank you, sir, for being here.
Thank you.
Question's been called. Any objection to the question? All right, seeing none. Members, looks like we're going to be voting to send House Bill 524 to Finance, Ways and Means. All those in favor, vote aye. Those opposed, vote no. Has everyone voted? Anybody like to change the vote? All right. Madam Clerk, if you take the vote.
You have 18 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations. House Bill 524 is moving to Finance, Ways and Means.
Thank you, Chairman Committee.
You're welcome. And Representative Rudder, I'm sorry. While you were up here a while ago, I should have pulled up item 49 as well. You had 49 on this calendar. And that's House Bill 534, ma'am. And I don't see any amendments, no testimony. So if you just let us know what's going on there, I'll try to.
I appreciate that,
You're
Mr.
welcome.
Chairman. Last year, we passed legislation to ensure that all school buses and school bus drivers have adequate insurance coverage and proof of that coverage. However, we discovered a discrepancy in the statutory language, and the terminology used could cause the school bus drivers to obtain separate liability policy in addition to the owners. This bill resolves that discrepancy. Specifically, it replaces the terms owners and operators with contractors. This clarifies that individual bus drivers and owners who don't directly contract with the systems are not personally responsible for securing insurance. This change makes it clear that the responsibility for providing insurance and proof of that insurance rests with the contractor. That's the bill.
Thank you for the explanation. Members, any questions for Chair Lady Rudder? All right, seeing none. Question's been called. The injection of the question. All right, seeing none. Members, it looks like we're going to be voting to send House Bill 534 to calendar and rules. All those in favor vote aye. Those opposed vote no. Has every member voted? Anybody like to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. Congratulations. House Bill 534 is moving to calendar and rules.
Thank you, Mr. Chairman and committee.
You're welcome. Members, if we could move without objection to item 38. Chair Lady Littleton, I know you had a guest here as well.
I do, yes.
That's members, that's item 38, House Bill 1359. And you've got a motion and a second. I'm looking at a couple of amendments here. The latest amendment is House Amendment 6325.
That's one I want to go with, please.
Very good. Members? Second. Got a motion and a second. Any objection to adopting House Amendment 6325 to House Bill 1359? All right, seeing none. All those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended. You're properly recognized.
Thank you, Mr. Chairman. This is part of the Foster Child Bill of Rights, and as amended requires that any foster child in the custody of DCS or an agency that contracts with DCS has the right to go to school and receive an education that fits the child's age and individual needs, benefits from appropriate care and treatment in the least restrictive setting, to live in a safe and healthy environment, and report any violation of personal rights without fear and retaliation. And it goes on, but we do have a guest that wants to speak that was part of the foster care, and if she could come and speak.
Members, any objection? Seeing none, we're going to go out of session and hear from Ella Brennan. Oh, you're right there. All right, your mic's on. You have 2 minutes, and then we can have an opportunity for members to ask questions. You're properly recognized.
My name is Ella. I'm 19, and I aged out of foster care a little over a year ago. I wrote this bill, and with the partnership of Representative Littleton, Senator Hale, and DCS, we've settled on the final language before you today. But to understand the necessity of this bill, I need you to understand why I wrote it. As a foster kid, my autonomy, my voice, and often my humanity were completely stripped from me, as my well-being was entrusted to caseworkers who were so overburdened they couldn't defend my best interests. Twice, I reported violations of what I thought were my rights, and twice I was dismissed. The goal of this document is to empower caseworkers, youth, and every adult in the ecosystem of their lives to understand what their rights are, as well as to become literate in more specific DCS policies that afford more specific rights. And this document requires that a judge review these rights with youth annually to ensure no child slips through the cracks and doesn't know their rights. It's unfair to expect DCS to enforce rights that don't exist. And so today, I'm here on behalf of the over 8,000 foster children in Tennessee. And I'm here with a reminder. When I entered foster care, I became a ward of the state. Tennessee became my legal guardian. So I urge you to consider this legislation not as if you are voting for your constituents, but as if you are voting for the future of your child. You are the elected representatives of the state of Tennessee. We are the children of the state of Tennessee. We are your children, and we are begging you for your support. Thank you.
Thank you. And thank you for being here. Representative Johnson, I have you first on the list.
Thank you, Mr. Chair, and thank you so much for being here. Your voice is so important in this area because you come from foster care. And so often folks who come through from foster care are either afraid to speak up or worried about it. And I just appreciate it so much because you spoke to everything that we know, an overcrowded system, you know, workers that have too many on their caseload to be able to advocate for those clients as they need to. And so many times those voices are not heard, and those are our most vulnerable. So thank you so much for, you know, not only writing this legislation, but stepping up to stand up and be a voice for those who are voiceless.
Of course, thank you.
Very good. Members, I have Representative Palliser, you're next.
I just want to echo some of those same comments. My father was actually in foster care for a time, and my mother's mother, my grandmother, was also in foster care in different states. But I admire your courage and you know, your ability to come out and so eloquently speak for those other foster cares. I think your words are very powerful, and we should definitely always fight and stand up for the foster children in this state. And look forward to seeing you up in my seat one day with the powerfulness of your speaking. Thank you.
Very good, members. I do not have anyone else on the list. Now I have Representative Towns. You recognize?
Mr. Chairman, thank you. And young lady, thank you as well. I want to reiterate something that you said that is very, very powerful, and we need to be reminded. You were a ward of the state, which makes the state your parents. That is very powerful and profound, because many times we probably forget that, okay? And thank you for the reminder. And as the parents of those that are wards of the state, we need to look at doing the best thing for our kids, okay? I have a personal question for you. What are you doing now? You're out of the situation. What are you doing now?
I will be attending university in the fall. I'm on a break because this, as you guys know, is a full-time job. But I will be attending university in the fall and hopefully eventually going to law school.
Oh, fantastic. Good, 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 good. Well, we'll be watching you, okay? We know you're going to do well. And feel free to come back and talk with us where we can help, okay? But thank you very, very much for what you did today, okay?
Thank you.
Members, anyone else? Representative Scarborough, sir, you recognized.
I was sitting there watching you, and I was really admiring what you were doing. I mean, you were speaking from the heart. I didn't see any notes up there. You did a good job. You talked about us voting for you as if you were our child. Well, I'm very proud of you.
Thank you.
Yeah,
Very good,
awesome.
members.
That's awesome.
Thank you, sir. Members, anyone else? Any objection to going back into session? All right, seeing none. Thank you for being here so much. And next, I have Leader Lambert, first on the list.
Move previous question.
All right, question's been called twice. Members, any objection to the question? All right, seeing none. Members, looks like we're going to be voting to send House Bill 1359 as amended to government operations. All those in favor vote aye. Those opposed vote no. Has there been a vote? Anybody like to change the vote? All right. Madam Clerk, take the vote, please.
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
All right, very good. House Bill 1359 as amended is moving to government operations. All right, very good. Chairman Todd, sir, you're recognized.
Thank you, Mr. Chairman. We have a special guest I wanted to recognize today that's with us today. Christopher Holton is here with the Center for Security Policy. He's directed the center's Divest Terror Initiative and Sharia Risk Due Diligence Program, and we just appreciate him being here with us today. Thank you, Mr. Chairman.
Very good. Thank you. Members, we can just continue. I know we're bouncing around a lot. It's just that time of year. I've got some members that have been there a while. If we could move to item 54, that's House Bill 601. Representative Freeman has that. So you have a motion in a second, and I have House Amendment 6334, sir. It's item 54.
Thank you, Chairman and committee, and what a great bill I'm following. Proud of the work you guys just did.
And we have House Amendment 6334, members. 6334. Do we go on once? Do we have a motion?
Motion
and a
second, guys? Anybody?
There we go.
Anybody?
Motion and a second. Sir, is that something you'd like to adopt?
Yes, please.
All right. Members, any objection to adopting House Amendment 6334 to House Bill 601? All right. Seeing none, all those in favor say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended. You're probably recognized.
Thank you, Chairman Committee. Amendment 6334 makes the bill and reflects a compromise between the Tennessee District Attorney's Conference and the Tennessee Innocence Project. Currently, under Tennessee law, there's no legal path for people with new non-scientific evidence of innocence to get back into court if they had entered a plea of guilty. This bill solves that problem by creating a pathway for innocent people to have their case heard. The law gives the judges ability to reopen the case of innocence when an agreed petition is filed by both the District Attorney General and the convicted individual or their counsel. This change of law provides a mechanism to get these cases back into court while assuring these petitions are only heard in the very rare situation of actual innocence. With the amendment, the Senate Judiciary Committee, which they've already done, brought the bill back. So with that, I've got some testimony if we'd like to talk to folks, or happy to answer questions.
I know some members heard this. We've heard this in sub. Members, any additional questions for Representative Freeman? Leader Lambert.
Thank you, Mr. Chairman. And Representative, I know we've talked about this privately, but I did want to just publicly state my concern here is that this is after a guilty plea. I mean, somebody has evaluated the information they had before them, chose to plead guilty, and then you have families, victims, you have officers, you have witnesses. I mean, everyone, the case is done. I mean, the case file goes in a drawer somewhere, if that, because I mean, the case is completed. And after someone has pled guilty, maybe years or even decades later, you know, something comes up and the person says, well, look, I now don't want to plead guilty anymore and want to go back into court. And I have an issue with that just from the victim's standpoint and victims' families. And I understand you're trying to help the defendant and those that are incarcerated on this, and I understand that. But that's just my only concern is that these people have chosen to plead guilty. They had competent counsel with them. There's no argument about that. That would have already been at the point of a writ of coram nobis that had already been all fought out by that point. Yeah. And so with the benefit of competent counsel, they pled guilty, and I just think it should stay there. So that's just my opinion.
Representative Freeman.
Thank you, Leader. And I do appreciate your comments. And I just want to make sure and clarify, this is for people where new evidence has come forth showing that they're innocent. It would have to be reviewed and approved by the District Attorney General and the council, and then approved by the judge to have it be reopened. So this is not people willy-nilly deciding that they want to change it. And I would also like to point out that this same ability is offered for those who are found guilty. So if you go through the process and you're found guilty and new non-scientific evidence is brought forth, you can have your case reheard. So this is just aligning those two cases. There's a multitude of reasons, and I've had a disagreement with folks before over why people would or wouldn't plead guilty if they actually weren't guilty. I'm listening to a book right now by John Grisham that accounts multiple cases of people that have pled non-guilty or pled guilty that have actually been found to be innocent later. I have no interest in whipsawing the families of these people, but also think that it's our duty to ensure that if someone is innocent, that they have an opportunity to have their case reheard and let the process work itself out. And that's my hope with this bill, and working through it with the DA's conference and the Innocence Project. I really believe we are in good posture here for this to happen. Anyway, but I really and truly appreciate your position.
Members, or excuse me, Leader Lambert.
And the only follow-up will say is, again, it is folks that are alleging that new evidence could prove that they are innocent. I mean, these are not folks that are, because new evidence has come up, it's like automatically, oh, wow, yes, these folks are innocent. You're opening up a pathway for them to allege that they are innocent. And so, I understand, the point. And if you fought it all the way to a jury trial and a jury finds you guilty, I mean, obviously there are lots of pathways after that. You have continued to proclaim your innocence. But once you have pled guilty, to me, I just think that it should be over at that point. But thank you. And I completely understand why you're bringing the bill, and there are some unusual circumstances out there. So I completely understand.
President Freeman.
Then last thing, and again, fully appreciate your comments. Currently, under state law, if scientific evidence is brought forth and you have pled guilty, you can have your case reopened. So this, again, just aligns the two types of evidence and aligns whether or not you pled guilty or been found guilty, so that we can, again, ensure that people who are innocent are not serving time for a crime they did not commit. So thank you. With that, I renew my motion.
Very good. Next on the list, I have Representative Towns.
Mr. Chairman, thank you. And thank you for the bill as well. In a perfect world, Mr. Chairman, everything that we heard actually applies. Unfortunately, in our world, our lawyers, our prosecutors, and our people that commit crime, it's not a perfect scenario. I know personally of many cases where people have actually committed a guilty verdict to themselves, and they were not guilty. They were afraid. The system was overwhelming to them, and they thought that if they pled guilty, they may get less time or whatever, and they take the case, and they plead guilty. These things come out oftentimes now on TV shows and this, that, and other. For many years, I couldn't understand that. Why would you say you were guilty to something that you did not do? It just sounds illogical, but it does happen. And it happens more times than not. One of my greatest fears would be if I was a prosecutor, when I had to prosecute someone, and I ended up prosecuting that person, and they ended up getting the death penalty, and comes to find out because of later data and evidence that that person wasn't guilty, that would bother me. Even if they got 10 years, that would bother me. But that's the kind of human being I am. But, and the fact of it is that, and if they're guilty, and we find that they're guilty the second time around, obviously, we have done our justice to the family or to whomever the victim is, and we've done our justice to the other side as well. I tend to want to err on the side of making sure that we have the right person for whatever it is they have allegedly done. So, and I feel better about the bill when you said that it protects us on each side. Got those protections. That makes me feel a lot better about it. Mr. Chairman, thank you.
Thank you. Next list, I have Representative Travis.
Thank you, Mr. Chairman. Previous question.
Very good. Previous question has been called. Any objection to the question? I have objection. Members, all those in favor of previous question, vote aye. 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 All those opposed say no. No. Ayes have it. Members will be voting to send House Bill 601 as amended to calendar and rules. All those in favor, vote aye. All those opposed, vote no. Has every member voted? Would anybody like to change their vote? All right. Madam Clerk, if you take the vote, please.
Mr. Chair, you have 11 ayes, 8 noes, and 0 present not voting.
Very good. Representative Freeman, House Bill 601 as amended is moving to calendar and rules. And we'll go ahead and members move to the next item. Representative Freeman has as well, House Bill 679. You got a motion in a second. Members, there's also House Amendment 5119 on this. Do we want to go ahead and adopt that, or do I have a motion? Do I have a second?
Yes, please.
You got a motion and a second on that as well. Remember, any objection to adopting House Amendment 5119? All those in favor, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended, and you're properly recognized.
Thank you, Chairman and Committee. So every 9 minutes, Child Protective Services finds evidence or claim of child sexual abuse. 2 out of most victims under 18 who are victims of rape are between the ages of 12 and 17. 1 in 9 girls, 1 in 20 boys under the age of 18 experience child sexual abuse or assault. Females ages 16 to 19 are 4 times more likely than the general population to be victims of rape, attempted rape, or sexual abuse. And of these, 93% are known by the victim. 59% are acquaintances, 34% are family members. And what this bill does is just makes it extremely clear that if you are a minor and you go to get a rape kit taken at a facility, that you do not have to have parental consent. And let me tell you why this is important. If you have a family member that has victimized a child, you now put the parent in a position of trying to decide as to whether or not they're going to have this rape kit done. If it is a business leader or a spiritual leader in your community, you have to have the parent deciding whether or not, I don't think that's how this should work. And so again, this bill makes it clear that minors can have rape kits taken without parental consent. And with that, I stand ready to answer any questions.
Members, any questions for Representative Freeman? Excuse me, Leader Lambert, you're recognized, sir.
Thank you. Now, this is a really good bill. So I just want to say that. I mean, I legally think they can do this now, but it is extremely important to clarify it. It's extremely important that evidence be collected as soon as possible. So thank you for carrying this. It's the whole reason I carried a bill last year that I think these people deserve the death penalty. If you're going to rape a child, you should suffer the worst consequence. So, I mean, just thank you for bringing this. And it's very important that we have the evidence that's needed.
Very good. Members, any additional questions for our sponsor? All right, seeing none. Question's been called. All those in favor of adopting, question's been called. All those in favor of sending House Bill 679 to calendar and rules, vote aye. Opposed, vote no. As I remember voting, anybody like to change the vote? Okay. All right, Madam Clerk, will you go ahead and take the vote, please?
Mr. Chair, you have 18 ayes, 0 noes, and 0 present not voting.
Very good. House Bill 679 as amended is moving to calendar and rules.
Thank you, Chairman Committee.
Thank you. All right, members, we could once again move to item, so Representative McCalman's back there. Sir, we're going to get to you. Item 30. House Bill 973. 973. And it does not have, it's item 30, members. I apologize. House Bill, I know we're hopping around. House Bill 973. There's no amendments. You've got it's properly motion second, and it's all yours.
Thank you, Mr. Chairman. Good afternoon, members. House Bill 973 simply increases the statute of limitations to 30 years from 25 on essentially every sex crime in the state, from 25 years to 30, and civilly from 15 years to 30, both instances past the 18th birthday of the victim. With that, I stand ready for questions.
Members, any questions for Representative McCalman? House Bill 973. Seeing any objections to the question? All right, seeing none, members, we're going to be voting to send House Bill 973 to calendar and rules. All those in favor, vote aye. Opposed, vote no. Has every member voted? Anybody like to change the vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes, 0 noes, and 0 present not voting.
Very good. Item 30, House Bill 973 is moving to calendar and rules. Congratulations.
Thank you, Chairman and committee.
Very good. All right, members, and thanks again for hanging with us today. If we could move to item number 14, that's House Bill 55. All right, it's by Leader Lambert. Sir, you got a motion and a second?
Thank you, Mr. Chairman. There's an amendment here that makes the bill. It's Amendment 3418.
Very good. All right, so we got on House Bill 55, probably motion second, and we have House Amendment 3418, motion and second. Members, we can go ahead and adopt that amendment. Any objection to that? All right, seeing none, all those in favor of adopting House Amendment 3418 to House Bill 55, say aye. Aye. Opposed, say no. Ayes have it. Leader, you're properly recognized.
Thank you, Mr. Chairman. This is an effort to try to curb some of the more extremism that we've seen out there, and it updates the code in a variety of ways to combat that. I stand ready for questions.
Very good. Members, any questions for Leader Lamberth? All right, Representative Johnson, you're recognized.
Thank you. My question relates to the littering portion of this. If you are with a group who is organizing a protest and you someone leaves behind a sign or leaves behind something like that, would that be fall under the statute?
Leader?
No, it would not. It would have to have with the intent to intimidate another from the free exercise or enjoyment of any right or privilege secured by the Constitution or laws, or the one after that. So it requires a second step, not just leaving the pamphlet behind or even just regular littering. That's why it takes it from a C misdemeanor to a B misdemeanor.
Very good. Any follow-up?
I guess that's just some of what I've heard that the concern is the interpretation there. But thank you for that clarification.
Very good. Members, any additional questions for Leader Lamberth? I have Vice Chair Davis is next on the list.
Thank you, Mr. Chairman. And so that was kind of my question too, with regard to littering or unsolicited flyers. And so I really just want to reiterate, under Section 6, it says that it has to have that intent to unlawfully intimidate another. So I appreciate that, Leader Lamberth.
Absolutely. You Knox County folks really like your flyers. But.
Very good. And I have Representative Hardaway. You're next on the list. Then I have Representative Travis.
Thank you, Chairman. And to the sponsor, would this include hate literature? If I get KKK in my door, can I call law enforcement and have that rascal hauled off?
Depending upon what's there, I mean, it would have to be with the intent to unlawfully intimidate another from the free exercise and enjoyment of any right or privilege. Now, you have a First Amendment right to put just about whatever you want on a flyer, but if you're littering or trespassing, so you'd have to be committing both of those crimes already, it would bump it up a notch if it's with the intent. And again, with those exact wording, and I want to be careful. It's that exact wording. This is going to be a pretty tough thing to prove. I mean, it's going to take a really egregious circumstance. And I will tell you that one of the things that actually sparked some of this is working with the Nashville Police Department when they had synagogues that were bombarded by flyers that were stuck up under their windshield wipers that made it very clear that they wished the people that were inside those synagogues to die. They wished death upon them, and they did it over and over again. And that keeps them from being able to worship, which is a protected right under the First Amendment. And so it's going to almost take repetitive action, not just one flyer or something like that, but you're making it clear that you're trespassing or littering with the intent of infringing upon their rights, because my rights stop where yours begin and vice versa.
Representative Hardaway, any follow-up?
Just to comment that my mom would tell me when me and my brother were fighting that my rights end where his nose begins. So, thank you, Mr. Chairman. Thank you, sponsor.
Very good. Now, I misspoke a while ago. I have on the list, I have Representative Todd, excuse me, not Travis.
Thank you, Mr. Chairman. Move previous question.
All right, previous question has been called. Any objection? All right, seeing none. Members, looks like we're going to be voting to send House Bill 55 as amended to Finance, Ways and Means. All those in favor, vote aye. Opposed, vote no. Has there been voted? Anybody like to change the vote? All right, Madam Clerk, you take the vote.
Mr. Chair, you have 15 ayes, 4 noes, and 0 present not voting.
All right, very good. Item 14, House Bill 55 as amended is going to be moving to Finance, Ways and Means. And members, if we could, we're going to be moving, and I'm going to apologize to the front row of members for most of you all. We're going to be moving to Representative McGrill's bill. I believe it's item 5. There's a significant amount of testimony on that bill, so we may not get to your bills, and I do apologize about that. I'm sorry. Her. Okay. All right. All right, folks and members, now we're on item 5, House Bill 809. And I believe you've got a proper motion and a proper second, so you should be properly recognized. And there's a whole slew of amendments here, sir. And I believe the last one is 6944. Does that?
6945, Mr. Chairman.
6945, member,
Yes.
6945. You got a motion and a second. Now, does that amendment rewrite the bill?
That is correct.
Make significant changes? And
That's correct.
That's what we need to be talking about. Members, any objection to adopting House Amendment 6945 to House Bill 809? All right, seeing none, all those in favor, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bills amended, sir, and you've got it.
Thank you, Mr. Chairman and committee. I know y'all have seen a few emails about this and had some different people come by to talk to you. Most of you know that I'm a full-time row crop farmer, and my family has been farming for 9 generations. And this occupation, it has its challenges both in and out of the field. We are constantly looking for new technologies, new methods, anything we can to make us more productive while maintaining the most plentiful food supply in the world. My farm, we use no-till farming practices on a majority of our cropland, and this ensures that we do not have to stir the soil to plant the crop. Because of this practice, we have been able to drastically reduce erosion and are better stewards of the ground that God has given us to oversee. This type of farming is very dependent on crop protection products. These products help keep weeds and grass at a minimum. They protect against fungus and disease that will destroy the yield in our fields. All of this adds up to being profitable or going broke. We need these products. Without their availability, we will not be able to continue to produce the food supply that we often take for granted. It would be a tragedy if we were to get to the point where we had to depend on foreign suppliers for our family's nutritional needs. This legislation provides protection to companies that develop and manufacture these types of protectants that my family and many other farmers use. The company that has a product will apply to receive a label through EPA's Federal Insecticide, Fungicide, and Rodenticide Act. This process is time consuming. It takes somewhere 10 to 12 years, several millions of dollars. And if the EPA is satisfied that the company has a product that meets their standard, the EPA will grant approval to the company that has applied for that label. This company is required to place the approved label on their product. This company cannot change, add, delete portions of the granted label without being in violation of federal law. And what is happening is that companies are being sued for not placing a warning on their label that they, by federal law, cannot add. This bill gives protection to those companies. And I'm fearful that these types of lawsuits will eventually place such a burden on new chemistries that the fear of unwanted litigation will prevent investment from chemical companies to develop new technologies that the industry that I represent needs so dearly. And with that, Mr. Chairman, I'm sure we're going to hear some testimony.
Very good. Members, we do have a lot of folks that have asked to testify today, close to 16, maybe 18. So do we want to go ahead and do we want to hear testimony? How do we want to move forward? I'll take a motion if you have questions. Excuse me? All right, members, any objection going out of session here from our guests? All right, seeing none. All right, if we could hear from, if we could bring up basically just 6 at a time at the seats there. If Bernadette Pager could come on up here, Ms. Pager. If I could get Alexandra Munoz, ma'am, if you could come on up. And Brenda Causey, if you would also make your way up here. Danny Ellis, sir, if you could come on up. And Alexandra Grant, if we could have, ma'am, if you could come up here. All right. Okay, looks like we have maybe a couple that's not here. Okay, so we'll just go ahead and we'll bring up, if we could bring up Casey Pistona. Are you here? And then Amy Miller. Are you here? Yeah, come on, you can sit in the last 2 seats there. All right, here's what we can do. If we can work from Ms. Bernadette, well, we'll start with you once your light comes on. And we've got 2 minutes, folks, because we just have a lot of testimony. I wanted to give everybody an opportunity to be heard. So your mic's on, you've got 2 minutes. And if you hear something repetitive, let's try to skip over that because we don't want to go over the same thing more than once. We want to be very effective and efficient. Okay, ma'am, if you could just start who you are, all y'all introduce yourself. Once she's finished with her 2 minutes, we'll just move down this direction and we'll open it up for questions for all 6 of you, okay?
Okay,
Thanks.
thank you. Yes, hello, my name is Bernadette Pager. I'm with Stand for Health Freedom. House Bill 809, as amended, potentially makes an insufficient label a defense for a pesticide maker. Why would a Tennessee registered EPA approved under FIFRA label lack sufficient warning? And why would a label consistent with EPA's most recent human health assessment be insufficient warning? Number one, it's because the manufacturer themselves draft the label and they back it with the data that they have completed and supply to the EPA, and the EPA does not independently validate the data. The EPA has no process for making sure that the data is completely accurate. EPA does no independent testing, and they don't subpoena full testing records to make sure nothing was kept from them. The EPA does not guarantee that a label that they deem compliant with FIFRA to be accurate. They are not responsible if the approved label is not accurate. Manufacturers remain accountable for label truthfulness, sufficiency, and updates. FIFRA clearly states in 7 USC section 136A F2, quote, registration, not a defense. In no event shall registration of an article be construed as a defense for the commission of any offense under this act. Approved labels can reflect bad data, new risks that emerged since the label was approved, label tampering, and more. When, for any of these reasons, a label was insufficient to prevent harm, misbranding laws and lawsuits step in to force corrections. Supreme Court Justice Stevens said in 2005 pesticide case, quote, private remedies that enforce federal misbranding requirements would seem to aid rather than hinder the functioning of FIFRA. FIFRA was written to work with state-level actions, not to bar them. And there's a great danger for public health and consumer safety in relying on the EPA's most recent human health assessment of any product. Products are only reevaluated every 15 years, and there are more than 16,000 licensed pesticides in the U.S., more than 15,000 in Tennessee.
All right, thank you, ma'am. That's your 2 minutes is there, but we'll have some time for questions. If you would, go ahead and just, once your red light comes on, introduce yourself, and you've got 2 minutes as well.
Thank you for recognizing me, Chairman Farmer. My name is Dr. Alexandra Munoz. I am a molecular toxicologist, and I specialize in understanding how different toxins cause cancer at the cellular level. I am opposed to HB 809. First, I want to make clear that the labels on many pesticides do not reflect the published peer-reviewed scientific data. Glyphosate is a carcinogen that causes cancer, and there is substantial evidence to support that, not just one study. There are many studies, and I have sent you a report detailing these mechanisms. Bayer Monsanto has consistently manipulated the system and knowingly submitted data to the EPA that doesn't reflect the actual health harms of their products. But what I want to talk about right now is the absolute worst scenario that this bill can bring about. Let's say in 2028, a company releases a new product. Under FIFRA, the company will submit its own safety data to the EPA. And because the company knows that the product is harmful, it has intentionally structured its studies in a way that show that their new chemical is totally safe. So now the label has no warnings of any types of harms, and the EPA approves it. Then, because the chemical is so safe, it is used as in playgrounds to control bugs at children's schools. In 2065, we find out that all the girls at the schools where this chemical was sprayed are now married and can't have children. The chemical exposure has left them infertile. They want to file a class action lawsuit against the company, but because of HB 809, even with the current amendment, there is no action that they can take, even though the company knowingly deceived them. This is the nightmare scenario that this bill can bring about. Companies will feel confident putting this product on the market, knowing that they can get away with this harm. And if this company happens to be controlled by a foreign adversary, then it means that by allowing this bill, you would be sanctioning an act of bioterrorism against the girls in the state of Tennessee. I ask you to vote no on this dangerous piece of legislation. Thank you.
Thank you. Perfect timing on that one. Ma'am, as soon as your light comes on, go ahead and introduce yourself, and you have 2 minutes as well.
Hello, my name is Brenda Causey. My husband and I are local beekeepers and business owners in Robertson County, Tennessee. Thank you for allowing me to speak today. As you may have heard, over 70% of managed beehives in the United States have died. Last year, it was over 50%. These losses year over year are unsustainable. Commercial beekeepers are going bankrupt and leaving the industry. They can't go on like this anymore, and neither can the bees. Cornell bee experts are analyzing samples of bees now to help identify the cause. They say this will be the biggest loss of honeybees and honeybee colonies in U.S. history. 2 years ago, Florida beekeepers experienced similar losses of up to 90% of their colonies. Early indications are that neonicotinoid pesticides are to blame. Secretary of HHS Robert Kennedy Jr. recently tweeted, quote, Bayer is essentially bribing both Republican and Democrat Congresspeople to insert an extraordinary provision into the Farm Bill that would give the German company immunity over its pesticides, especially Roundup. If these products are as safe as the pesticide companies claim, then why do they need a liability shield? This bill violates the 5th, 10th, and 14th Amendments to the Constitution. Tell me, are you as outraged by this as I am? Unquote. If you give these companies immunities now, they may use it for every other chemical they come up with, and it will be worse than glyphosate and all other pesticides combined. When they release this next more potent, devastating pesticide, do they get immunity for that one too? How does this bill benefit the people that you represent? Please think about the people in this state and the repercussions to them if you pass this bill. Do you want to be the lawmakers on record who let Monsanto off and Bayer off scot-free when they have done so much damage to the environment and to the health of Tennesseans? Thank you.
And thank you, ma'am. Sir?
Thank you, Chairman Farmer. Danny Ellis with the Tennessee Trial Lawyers Association. I appreciate the amendment, and so that will greatly curb my comments. Looking at the amendment as proposed, it says it will block all civil actions. As you may know, there are two types of lawsuits. You have criminal law, as Representative Lamberth will tell you about, and then you have civil. You have been told that this bill will not harm or will not block somebody's ability to a civil cause of action. The bill itself now says it will. Some will say, well, maybe you can bring it under contract. There are three types of contract causes of action that you can bring: breach of express warranty, breach of implied warranty for merchantability, and breach of implied warranty for fitness for a particular purpose. All of these will deal with property damage issues, not with personal injury issues. And a person will not be able to bring this type of cause of action because what they're going to say is, hey, I wasn't warned of this. That's what the breach is. This bill will keep that from happening. As far as product liability and as far as common law negligence, this bill explicitly says that will block it. I've heard several times, well, if a person just has to show that they're sick or they've had cancer, contracted cancer from this, and they'll have a cause of action. They will not. What will happen is this bill will block that individual's lawsuit. And if they file a lawsuit and this bill is passed, that person will then be subject to sanctions under Rule 11 of the Tennessee Rules of Civil Procedure. Last, I will say that people have said, well, these are going to be federal class action lawsuits. This won't apply. In federal cases, there are federal questions and diversity. Federal questions would be a civil rights case. This would fall under diversity because it's between individuals of two different states. In a diversity action, state law applies. As it is written, this law will bar any Tennessean from being able to bring a lawsuit. Last and foremost, I appreciate the attempt to do an amendment under the EPA under subsection B. The problem is the EPA does not have that authority or the mechanism to investigate fraud. And it is an amendment and it is an exception without force. Thank you.
And thank you, sir. Ma'am, you're properly recognized.
Thank you for the opportunity to speak today. My name is Casey Pistona, and I'm proud to call Nashville home. Before moving here, I lived in North Alabama. As a kid, I was an Army brat and lived in Anniston, Alabama for about 7 years. Anniston is where I first learned what it meant to be part of a community. You may have heard of Anniston because of Monsanto. Decades ago, Monsanto operated a factory there producing PCBs, harmful chemicals used in plastics and pesticides, until they were banned in the 70s. Monsanto knew these chemicals were toxic decades before that. They knew they were poisoning the land, the water, and the people of Anniston, and they did it anyway. Anniston won a lawsuit proving that Monsanto knowingly polluted the town, destroying lives in the process, but justice came too late. I watched the community that raised me fall apart. I watched neighbors and loved ones get sick. I was only 5 years old when I lost my mother to cancer, and years later, I watched my sister fight and thankfully survive the same disease. Bayer Monsanto is pushing House Bill 809 to shield pesticide manufacturers from accountability. This legislation would strip Tennesseans of their right to seek justice against companies that knowingly sell dangerous products. Bayer Monsanto has spent decades proving they cannot be trusted to act in good faith. Our state government should not be stepping in to protect them now. This bill is not about protecting farmers. It's about protecting corporate interest. Just like Purdue Pharma hid behind FDA approval while fueling an opioid epidemic that is still devastating our country, Bayer Monsanto wants to hide behind EPA-approved labels to avoid responsibility for the harm their pesticides may cause. That's why I'm asking you to oppose House Bill 809. True prosperity cannot come at the cost of our health, our environment, or our communities. We cannot afford to protect corporations that have shown time and time again that they do not care about us. Please do not let another town become Anniston. Do not let another family endure what mine has. Please vote against this bill.
And thank you for that. Ma'am?
My name is Amy Miller, and I'm a mom. I've spoken to several families and other mothers across the entire state. What concerns us is that you have Bayer, a big multi-billion-dollar corporation, coming into our state and having this bill brought when there are so many gray areas, but yet there are so many black and white areas. It has been proven that they have used fraudulent practices, ghostwriting, and other ways to manipulate the label on their product. Why is our state going forth and trying to get them a liability shield? This makes no sense. This is a federal issue. The feds are actually talking about this with President Trump saying we need to look at these chemicals in our foods. We know that one chemical such as glyphosate that keeps being brought up among other chemicals are in our food. They're in breast milk. They're in the kids' lunches at school. It's everywhere. Why are we advancing this so quickly? And everyone seems to think you can sue for harm. Can you? I don't think so. So the other issue that we keep hearing is that, we need to protect future technology. This is going to stop, as the sponsor said, this is going to stop, we might not have crop protection tools. Why are we advancing this so quickly when that future technology, we don't know the harms that are going to be done? So we're going to go ahead and give them a pass on that? That is dangerous. And I think we can use the example that we just came from called COVID. If we all remember how quickly everything advanced then, don't repeat that. We don't want to repeat that harm on people, and especially our kids. As a mother, these chemicals are harming our kids. This is the future of Tennessee. This is going to be a fiscal burden to Tennessee, all while giving these huge manufacturers a pass. Please vote no on 809 today, and let's think about it, and let's ask the federal government what they're going to do about it, because Secretary Kennedy and President Trump are looking at this right now.
And thank you, ma'am. Thank you for that. Members, we have, it's time for questions. Representative Johnson, you're first on the list.
Thank you. I guess, I keep reading that these pesticides are linked to male infertility, hormone disruptors, reproductive and behavioral dysfunctions in males, females, and children. So I always have to question, my big question always, and I'll pose this to all of you or anybody who wants to chime in. When you have a multi-billion-dollar company that wants immunity, why would a multi-billion-dollar company want immunity?
You want me to go first? Okay.
Yes, you're recognized. Sorry.
Well, I would like to just read something that is actually on Bayer's website right now. And if you can also read their annual report, and it does speak to some of that. But this is an image that I have in front of me from Bayer's website, New Lawn and Garden Formulations in the U.S. To further reduce future litigation risks, we have transitioned the manufacturing of our glyphosate products for the U.S. residential and LNG market, lawn and garden market, to new formulations that have different active ingredients starting in 2023. We have taken this action exclusively to manage litigation risk and not because of any safety concerns, they claim. The vast majority of claims in the Roundup litigation have come from residential LNG users, so this step largely eliminates the primary source of future claims. This action does not impact any of our glyphosate-based agriculture or professional products or Roundup products available worldwide. And then it goes on further. So this step largely eliminates the primary source of future claims. That's their own words.
Very good. And members, at this point forward, just from an operational standpoint from the mics up here, if we can just direct a question to one of our guests there, it would really be helpful. So Representative Johnson, you recognize any follow-up?
Yes, I actually would like to ask the attorney and the physician the same question as well, who typically wants immunity.
Well, I'm a toxicologist, and I think that from a toxicological perspective, it's very clear why they would want immunity. Pesticides and herbicides are often very toxic in their impacts, and they tend to have toxic impacts in 3 types of categories. They often produce cancer, they can be neurotoxins, and they can be endocrine disrupting chemicals. And endocrine disrupting chemicals alter the hormonal balance of males and females, and when these exposures occur at a young age, they can alter the sexual development in ways that affect children for the rest of their lives. It can lead to things like infertility, it can lead to loss of pregnancies, and there's substantial evidence, or there's emerging evidence, let's say, that glyphosate-based herbicides are endocrine disrupting chemicals that do impact fertility and that are changing the sexual development of girls because it is an androgenic chemical. And so that is the risk of these chemicals, and they're aware of the class of chemicals that they're working with, and it's a very wise decision to ask for this type of immunity, but it's a very dangerous decision for the people of Tennessee.
Mr. Ellis.
Thank you, Mr. Chairman. Representative Johnson, that's a great question. In 2019, the label that's the one that's being litigated right now, it was shown that that label was secured through fraud, only through the use of a lawsuit. In 2022, after the California case came back showing that there was fraud and that there was cancer, that with a link, the California EPA sent a letter to the EPA saying, hey, can we change this label and add this label and add the warning for likely to cause cancer? The EPA said, yes, you can do that. Bayer has not done that because it would rather have somebody provide immunity so that they can hide behind what they give to the EPA, and there will be no mechanism. They can come into here and they can lobby and they can pay lobbyists and they can put pressure on elected representatives instead of 12 individuals who are Tennessee residents who come together in a court of law with no background, no connection to each other, and who only want to show up to do the truth and to find the truth. And they would rather bring their power and their influence and their money to bear on a legislative process instead of a God-given right to a jury trial under the 7th Amendment and under Article 1, Section 6 of the Tennessee Constitution.
Thank you, sir. Next on the list, I have Representative Russell. Excuse me, Chairman Russell.
Thank you, Mr. Chairman. And my question is for the trial lawyers. If this bill passes and goes into law, will it affect current litigation?
Mr. Chairman, thank you. Representative Russell, that's a great question. As written, I don't know. It doesn't have a retroactive application that it's seen. So what I could tell you is if it's not retroactive, then it's cutting off everybody's right to a cause of action after it's been signed by the governor. For those that are in litigation, I would argue, if I was representing them, that it didn't because they have a guaranteed right already in existence. But I don't know. And so that would be something that would have to be litigated and decided.
Chairman Russell, any follow-up?
Thank you. That's all I got.
All right, very good. Representative Salinas, ma'am, you recognize.
Thank you, Chair. My question is for the toxicologist. Can you describe some of the experiments that you have seen and their safety for oncogenesis with glyphosate?
Mm-hmm. Yes, thank you for asking that question. So glyphosate-based herbicides are carcinogenic, and I know that there's been some dispute about whether or not that's true, but there is substantial data showing that this is the case. There have been a number of epidemiologic studies showing that people who have been exposed to glyphosate exhibit increased risk of non-Hodgkin's lymphoma, which is a type of cancer. And there's also been a number of animal studies showing that when animals are exposed, they develop many types of cancers. Now, at the cellular level, there's a certain set of mechanisms that glyphosate engages that make it clear that it is a carcinogen. So the first thing that glyphosate-based herbicides do is that they enter cells, and that's already a dangerous process for something to enter a cell. It means that it can impact what's inside of the cell. And inside of the cell, glyphosate-based herbicides produce oxidative stress, which is a type of chemical reaction that generates all kinds of really reactive molecules. And these reactive molecules damage lots of things that are in their space. One of the things that they can damage is the DNA. And when the DNA gets damaged, that's a genotoxin. And that is the very seed of cancer. And what these chemicals do is they cause something called double-strand DNA breaks. And so DNA double-strand breaks separate the helix of the DNA into fragments. And this has been measured in people that have been exposed. They've found DNA double-strand breaks. They've done it repeated in lab studies. There's substantial evidence showing that this happens. Once those DNA strand breaks occur, then the chromosome fragment gets encapsulated into something called a micronucleus. And that micronucleus is kind of like a small basketball, but it's outside of the main nucleus of the cell. And the DNA inside of a micronucleus becomes catastrophically damaged. It undergoes a process called chromothripsis, which mutates the DNA heavily, and then it's released into the cell. And that becomes reincorporated into the genome. So it actually creates a highly corrupted set of DNA that goes into the cell and continues to lead to the events that produce cancer. So there's substantial evidence here, and it also engages a pathway called NF-kappa B, which is directly linked to non-Hodgkin's lymphoma and the development of non-Hodgkin's lymphoma. So there's a very clear link at the molecular level that this is what's going on.
Very
Thank
good,
you.
Representative Salinas. Any follow-up, ma'am?
Yeah. So to be clear, so, you know, the biology of our cells, we have our cell membrane, and then we have a lot of other organelles in the middle, or nucleus in the middle, which is double. So it's really hard to get in there. So these compounds are getting to the nucleus and the DNA even after getting into our bodies. Is that correct?
Exactly. Yeah. And so I think that's one of the things that's most dangerous about it. Thank you for pointing that out, is that the chemicals go into the cells and then they get into the nucleus where they can damage the DNA. And that's why formulations like Roundup and other formulations that include things like surfactants that help the chemicals penetrate into plant cells better, those same types of features are going to help them penetrate into the nucleus better. And that means that when they're getting inside, they can actually damage the DNA. And that's not something that all toxins can do. So looking at this in terms of a formulation, because that is the exposure route, is the way to think about it. And it is the way in which it's the most dangerous to human health.
Representative Salinas, any additional questions?
No, that's it. Thank you.
All right, very good. I have Representative Towns, sir. You're recognized.
Oh, wow. Thank you, Mr. Chairman. Do you all know each other? Y'all don't know each other? Okay. Okay. Just infrequently there, randomly. Thank you all for coming and giving us this expert testimony on this particular product. This chemical, has it been outlawed anywhere else in the world?
Sir, if you just direct that question, maybe Mr. Ellis could answer that question for you.
Thank you, Mr. Chairman. I would defer to the toxicologist. But what I would say is there are several countries that don't use this product.
Okay.
And this, are we talking about glyphosate, or are we talking about all 15,000 that are registered that this bill would affect?
Glyphosate now.
So yes, it's prohibited in several countries, and the toxicologist would probably be the better person to ask that to.
Yes, ma'am. I'm sorry, forget your name.
Ms. Minos, is that? Is that okay? Please, you recognize.
I just want to be totally clear that your first question, that Amy and I have known each other for a long time, but in the course of the past 2 weeks, I've met several other people here. So I didn't want to imply that I didn't now know them. Okay.
No, don't worry about that.
Okay.
Okay. Thank you for that. Okay. Secondly, I'd love to ask you guys about.
Representative Towns, did you want the toxicologist to answer that question? I thought
she could.
She may know the answer. If you don't, then you can pass.
The status is, but there have been attempts to ban it in some countries, and then they've overturned it, and it's been a back and forth process because of the lobbying by the companies.
Okay. Okay. Most importantly, I've heard from you in the beekeeping business, that concerned me a lot. This product has something to do, you think, with the collapsing of the hives?
Yes, I do, yes. There's lots of studies that are being done right now on all the bees that have died over this last year. And then there's studies that have been done, over the past decades, also showing that pesticides cause damage to bees. She was talking about the reproduction of humans and girls, but it also affects the reproduction of bees too. There was a study that's finds reduced bee reproduction over 2 years. So it's compounding over years of being exposed to the pesticide.
Representative Townsend, any follow-up?
Yeah, just one or two. In the event that obviously that continues, the bees, obviously we know affects everything that all of us do, not just a certain segment of crops, but we have to have the bees across the world to do its job on our food. Is that correct?
Right. Bees affect about 35% of our food production.
So at present, do we have anything to offset and help the bees recoup and rejuvenate? As long as you're losing that pesticide, there's nothing that can offset that you know of?
Not that we know of right now.
Okay. Mr. Chairman, thank you.
All right, very good. Thank you. Next, I have Chairman Doggett, sir.
Thank you, Mr. Chairman, and thank you all for being here with us today. I just had a few questions. The first one, what specifically are individuals suing for in these cases?
I guess Mr. Ellis.
Thank you, Mr. Chairman. Representative Doggett, so there are in the paraquat cases, which is a banned substance worldwide, or in several countries worldwide. In the paraquat cases, they're suing for a causal link. They're saying more likely than not, and juries have found more likely than not, that paraquat, a registered pesticide that would be affected by this bill, causes Parkinson and other neurological issues. As it relates to glyphosate, since this is the topic of today, it is non-Hodgkin's lymphoma that is found mostly in males. And so, again, it is in a court of law, more likely than not, that the exposure to the glyphosate compound caused the non-Hodgkin's lymphoma, which is what they're seeking from that is future and past medical care. And they're also seeking, the issues of having to deal with the cancer and going through that process from that time and forward, all of which would be limited under Tennessee's statutory law because of the statutory caps on non-economic damages.
Very good. Chairman Doggett.
Thank you, Mr. Chairman. So out of those cases, were they able to actually prove in those cases that the chemicals caused the cancer, or were they just based off of the convincing of the jury that the jury believed that these chemicals caused the cancer?
Mr. Ellis.
Thank you, Mr. Chairman. So, Mr. Doggett, that's a great question. Representative Doggett, that's a great question, because the burden of proof in a case is more likely than not. That's when you weigh the evidence, what is more likely true than not true. It's not speculative. It's not, if you get 50-50, especially in Tennessee, you're out. And you have the burden of proof as the plaintiff to show more likely than not, with both sides getting to present their evidence. And once the jury looks at all the evidence and makes its fact finding, and as a practitioner of 26 years, 12 people in a jury want to do what's right. And I've lost cases that I thought I should win because the jury did what was right. They make a determination, yes. Now, as to the toxicology studies, I am not equipped to say that. But what I would say is if there is a jury verdict finding it, then they have found, and the plaintiff has proven, more likely than not, based on all the data in front of the jury, that it caused the cancer.
Chairman Doggett.
Yes, sir. Thank you. What we're talking about today is labeling. Is that correct?
Mr. Ellis?
Yeah, Chairman, yes. And the reason that it's the label is because this is a product that's being put out into commerce, and there's an idea of negligence, right? You have a duty, if you are putting a product into circulation, that it's going to not hurt people. And if it is going to hurt people, then you warn them of the risks. My example would be cigarettes. If you want to smoke and you go buy a pack of cigarettes, you can look at that label and go, hey, this may cause cancer. I get to make the decision for myself. I don't want to smoke. But with this type of pesticide and the labels that we're talking about, that harm is being hidden, and that is not reasonable. That's not what an ordinary reasonable person would do under negligence. And so, yes, it's a label, but it's a label that's hiding the harm that's being caused. And that's how the lawsuit goes forward. Did I answer your question?
Chairman Doggett.
Yes, sir, you did. Thank you. And I use a wide variety of chemicals in my real job that I do, and they all have labels on them, but I go and get the safety data sheets and review those, because I feel like, to me, I can get more information about different things that are associated with that chemical more so than the label. One thing that I have found commonly is if I see it on the SDS sheet, a lot of times it will appear on the label as well. And so I had looked at some of these SDS sheets because of glyphosate was one of it's been basically the topic of conversation today. But in two different places on the SDS sheet, it talks about how glyphosate was not a carcinogen in a lifetime of studies in rats and mice. That was on one spot. Another place on there, California Proposition 65, this product does not contain any substances known to the state of California to cause cancer. The product does not contain any substances known in the state of California to cause reproductive harm, which are some things that we had heard today. And so that's why it kind of gets confusing at times, because you wonder where was the burden of proof, or if it was just, I'm trying to juggle through it and sort through it, because I would think that if it was known to cause cancer somewhere, that somebody would certainly put that on a label as a precaution or a warning to you. But if their studies have shown that it hadn't, then they wouldn't necessarily have to label that. So,
Mr.
You're recognized, sir. I apologize.
Thank you. So Representative Doggett, so what I would tell you is when you're the person that controls the study and you're the person that controls the data sheet, you can control what goes on there. What we know for sure based on the lawsuits is that around 1983, there was an internal Monsanto study, and then the internal emails show, hey, look, we're starting to see tumors in these other in the rats and the mice that have this issue. This is in 1983. This is way back when. If we could just show one tumor in the control group, that would skew the results. And then we could say, oh, it's non-carcinogenic. And lo and behold, later on, guess what? There was a tumor found in the control group. So when you control the data, you can control what's put on there. Since that time, you've had multiple studies of independent individuals, independent agencies that show a link. That actually, I believe I am the one least qualified probably to talk about that. The toxicologist would probably be the best person for you to ask that question to.
Chairman Doggett.
Okay, I don't have to. One final thing. Thank you.
You're
'Cause
recognized.
I know time's running short, and I'm sorry. I don't mean to eat up so much time, but my final question is this. If they made a statement, for instance, on the SDS sheets, and I could prove otherwise, I could still sue just based off of the material that they put on the SDS sheet and not necessarily what they put on the label of the product.
Mr. Ellis.
By the way this bill is written, no, because the label, the EPA label, the FIFRA label is what would control and not the other.
Chairman Doggett.
But so I could not sue based off of what the SDS sheet says.
Not at all. And in fact, if you were trying to say it was a fraud issue, you would have to show that the fraud, i.e. I lied to you, is what caused your cancer, not that the chemical caused your cancer. So you would not have a cause of action. As this bill is written, the EPA label would control and would keep you from being able to bring a lawsuit.
Mr. Chairman?
Thank you.
Good.
Yes, sir.
All right. I have Chairman Eldridge, sir.
Thank you, Mr. Chairman. I'm moved to go back in session.
Do I have a second? Yeah, I have, there's four members on the list. Oh, so we have about, this, so everybody knows, this is kind of a status update on where we're at and what's going on. We have right at 15 more signed up to testify today, 15 additional people to testify today. So I was trying to give people time before we ran out of committee time today. So we spent a good 30 minutes here. So, but I'm at the will of this committee. There's been a motion, that's proper motion. And there's objection. So let's vote on it. Members, if we're going to be on the board. Sure. You're recognized, Representative Powell.
Saying that we're cutting off their testimony, we're cutting off all 15 additional people's testimony as well.
No, what the intent is to allow for additional testimony. We're not ending the testimony. We're going to stay out of session and allow for another 6 to come up. And then I was going to move that way. Oh, go ahead. Representative Slaves, you're recognized.
If you're only allowing 4 more people to testify, that's less than 1/4 of the people that signed up.
14. No, it's my intent to get every person that's signed up to testify in front of us today.
Well, I think if they signed up, they should be allowed to testify. That's what we're here for.
All right, we get members here. Here, let's do this. There's a proper motion here. There's objection. Is there still objection? Very good. Okay, members, we're on the board. All those in favor of going back into this. Hold on. All right, there's been a proper motion made. Let's go ahead and vote on this, and then we'll address the procedural issue once we're back into session. This is a unique situation. All those in favor of going back into session, vote aye. Aye. Oh, it was on the board. It's on the board. It's a motion to go back into session. Yeah, just hang with me here. We're gonna get there. All those in favor of going back into session, vote aye. Those opposed, vote no. All right, Madam Clerk, take the vote.
Mr. Chair, you have 10 ayes, 10 noes, and 0 present not voting.
Okay, the motion fails. We're going to stay out of session, and I'm going to ask the committee this question: do I have a motion to bring the next round of folks up, the next 6? Is that a motion and a second? Okay. All right. Okay. To stay out of session.
To stay out of session.
That's correct.
But we can still stay on these people because that's what we decided. That was I think I'm next on the list, but
I think the motion was to go back into session and it failed. We're out of session, and the intent was to bring the next round up. So I was just going to ask the committee if we could just bring the next round of folks up. That's what I'm asking. Okay, Leader Lambert, you're recognized.
Thank you, Mr. Chairman. I move that we bring the next round of folks up. We've had 30, 40 minutes of these fine folks testifying. I was watching from the back and in here. I would like to hear from the additional 14 folks that would like to testify on this. I think their voices are just as important as the 6 we've just heard. And so I move that we hear the next round of folks that would like to testify.
Very good. That's a proper motion, proper second. Okay, there's objection. We're going to be on the board for all those in favor of moving to the next round of testimony and guests, vote aye. And those opposed to hearing from the next round of guests, vote no. Madam Clerk, if you would go ahead and take the vote.
Mr. Chair, you have 14 ayes, 5 noes, and 0 present not voting.
And thank you so much. And thank all 6 of you for being here. And now what I'd like to do, if we could bring up 6 additional witnesses that's signed up to testify today. If we could bring up Mr. Timothy Baker, Kevin Hensley, George McDonald, Andrew Tharp, John Litz, and Tamara, excuse me? Yeah, we could bring Mr. Llewellyn up. Let's go ahead and do that. So that should be 6. And if everybody's not here, I'll call another up. I got you. Put Representative Hardaway on the list.
Do you want to testify?
All right. And if we could bring up, is Mr. Llewellyn up here? Is Timothy Baker up here? Is Mr. Baker here? He is not. So we are going to move, and we're going to also add Miss Tamara Arthur. Miss Arthur, are you here? If you could come up here as well. There we go. All right. Once again, we're just going to start from the right-hand side, my right, and we'll move this way. But before that happens, I have Representative Eldridge has asked to be recognized. Sir, are you recognized?
Thank you, Mr. Chairman. And it's good to have the opportunity to welcome one of my constituents who we also want to hear from today. Mr. John Litt's a former member of this body and formerly with USDA, I believe. Are you still with them, John? Okay. All right. But I want to make you feel welcome here and glad you came in.
Okay. Thank you so much. Okay. All right. Ladies and gentlemen, I'm going to start from my right, your left. Sir, your microphone's on. If you'd introduce yourself, everyone will have 2 minutes, just like the last group did, and we'll have some time for questions.
Yes, sir. Thank you, Mr. Chairman. My name's Andrew Tharp. I'm a lawyer with Butler Snow, and I'm here today on behalf of the Tennessee Soybean Association. My firm has also been outside corporate counsel for Tennessee Farm Bureau for about 40 years. I started my professional career in the United States Air Force. I was an officer for 8 years, and for 4.5 of those years, I was an Air Force JAG officer. Since then, I got out and I've been with Butler Snow for about 10 years, and I primarily handle products liability lawsuits. And so I wanted to testify today here to provide a brief anatomy or overview of the different forms of products liability lawsuit takes and how this bill will impact one component or one potential claim under a products liability lawsuit, and how it will not impact 2 potential claims that commonly arise under a products liability lawsuit. You have under products liability, a design defect, a manufacturing defect, and a failure to warn claim. Those are the 3 primary claims. This bill will only impact failure to warn. A design defect claim is like if you have a pen, a regular ballpoint pen, and you pop the lid off and a blade comes up from the pen. That is arguably inherently dangerous. It has nothing to do with the warnings. A manufacturing defect would be like if you had the same pen and you pop the lid off and a spring came out of the pen because it fell apart and it flew up and hit you in the eye. Has nothing to do with the warnings. The last potential claim that you can bring under products liability suit in Tennessee is a failure to warn claim, where basically you're taking issue with the warnings. That is the only claim that this bill will impact. It will not impact the other 2 most commonly found claims under a products liability action. This bill does not provide blanket immunity. Lawsuits will still be able to be brought. I'm happy to respond to some comments that I heard up here that I just flatly disagree with because they don't provide some the appropriate context or appropriate thorough hypotheticals that were set forth up here. But the bottom line is lawsuits will still be able to be brought against products manufacturers and pesticide manufacturers pursuant to the Tennessee products liability law in the form of those first couple of claims that I mentioned, that being design defect and manufacturing defect.
All right, very good. And thank you, sir. Right on the money there, time-wise. Sir, would you go ahead? Your mic's on. If you did introduce yourself, and you have 2 minutes as well.
Yes, sir. Thank you. I'm George McDonald from Smith County. I'm a 4th-generation farmer, and my daughter Sarah's a 5th-generation farming the original farm that my great-grandfather started in 1927. Today, we grow corn, soybeans, wheat, strawberries, watermelons in 6 different counties, including right here in Davidson County. I am old enough to remember how bad erosion was in Tennessee in the 70s and 80s. But due to no-till and the modern chemistry we have our precious soil erosion under control. All the pesticides we use on our farm are applied and used strictly according to the labels. These labels are very inclusive and include all aspects of these products. Pesticide labels, has already been mentioned, is regulated by, or FIFRA designates EPA to make that label and make it stringent. I see several of you in there up here that's got gray hair like myself. There's 27 pages right here of this label, 27 pages. And I see some people shaking their head. Well, you've got to have some really good glasses to read this. But believe me, we read those labels like they're supposed to be. When we buy our food in the stores, and if our food comes from foreign countries, we do not know what's been done to it, how it's been treated, or what it's been treated with. I want my food grown right here in the good old United States of America. I'm here to urge you to vote in support of this bill. I realize some say we're not taking chemistry away. That is correct, but we're chipping away at it. One chip at a time, just like a beaver takes down a tree. And if we take products away, chemistry away from modern agriculture, it will be the same as equivalent as taking tractors away from farmers. Thank you, Mr. Chairman.
And thank you, sir. You're next, and your mic's on. Just
Thank you,
introduce
Mr.
yourself, and you'll have 2 minutes.
Thank you, Mr. Chairman. My name is John Litz. As you can tell, there are a few that were still in the legislature when I was here. You know, I had 2 pages of notes here that I wanted to share with you, and I've got to reading through them. And after listening to the beginning testimony, I'm gonna shy away from some of those notes, and because I've sat in your chair, and I know that whenever you're sitting in there, you've got to make a decision, and that decision you make is going to be dependent upon facts that are given to you from the people that are testifying before you. First thing I'm going to tell you is that many of the people that apparently that are getting sick from this are people that are using pesticides and Roundup that they're buying from Walmart, which is a very extremely minute chemical chemical formulation that's used for household use in spray bottles. If this product is so bad, this is just a logical explanation of this. If this product is so dangerous and so bad and so deadly, it's been on the market for agriculture for 45 years. Why aren't George and I dead by now? Why aren't a lot of other farmers that have used it daily? Why aren't I'm sorry, I don't hear any finger snapping. But why is that the problem? I don't understand this. This, because it's not labeled on the label that tells that it is supposedly a carcinogen, that to get that put on there, it has to go back to the very beginning and start all over again. George hit on a few things there whenever he said that back whenever I was in high school, one farmer fed himself and 53 other people. Today, that same farmer feeds 160 people. And the reason why is because of technology. It's because of conservation farming, and it's because of the tools that we have as farmers to be able to produce enough food to feed a hungry world.
Thank you, sir.
With that, I'm done. Thank you.
Thank you, sir. All right, your microphone is on its way. It's on.
Great. Thank you. Thank you, Mr. Chairman. Thank you for the committee. My name is Dr. Craig Llewellyn. I'm a principal scientist in chemical regulation and food safety with the Exponent Group. I have more than 30 years of experience in whole animal, cellular, subcellular, molecular toxicology, working in consulting, industry, and for state government. I'm here representing the Southern Crop Production Association and Crop Life America. Just to give you a quick peek, and I think we've seen a little bit of quick peek, but maybe a little bit more is needed into FIFRA and its rigorous aspects of it. So we've heard that FIFRA is the overarching regulation, controls the label by EPA. EPA dictates and has requirements for the data that is required by registrants to produce, and also the assays that are used are demonstrated and to be robust and appropriate for use to evaluate the safety of products registered under FIFRA. And if a company or a registrant knowingly violates that, there are criminal provisions within FIFRA that would result in criminal prosecution and fines. It's also important to know that there's federal preemption written into the FIFRA law. that does not allow a state to make, enact, or any other labeling or packaging standards that are in addition to or different from the federal standards. So it's the law, the label of a pesticide is the one source of truth in terms of protecting users, consumers, and the public in general from pesticides. The one might think that a registration is a simple exercise. Well, it is not. Registrations are living. So once a pesticide is registered, we heard that the first registration for glyphosate was in 1974. These documents are living. Every new evidence is evaluated on an ongoing basis. There is a mandate for 15 years, reevaluate every registered chemical, but also at any time, anyone can bring evidence to EPA and ask for it to be evaluated, and EPA does that itself. So it's really important that at any time, the evidence is evaluated as it is generated. So new science gets generated, and that science is always under evaluation for all registered compounds in the United States. It is really important. The aspect of toxicology is the central tenet for toxicology is the dose makes the poison. Nothing is without poison. So even if we think about the substance in that water, the bottle over there, water is toxic as well. So it's all in the dose.
All right, your time's up. That was a signal that your 2 minutes was over. You got it. Thank you so much. Ma'am, you're recognized.
Tamara Arthur. I'm an elementary school teacher. In 1994, we heard from our dear friends that they had lost their 14-year-old daughter, Emily, to non-Hodgkin's lymphoma. The year before Emily's death, she, along with 4 other teachers from our children's school, were diagnosed with non-Hodgkin's lymphoma. Little Emily was 5 years old when our school first started using Roundup monthly on the school grounds. With the grass wet with Roundup, children of all ages were sent out for PE and recess. After Emily's death, as a concerned parent and teacher, I helped form a group that came together, spending the next 2 years researching and persuading our school board to incorporate an integrated pest management program that we wrote and eventually gave to Purdue University for implementation. In all our efforts, we were hoping to save many others, as we had found that glyphosate was the root cause of non-Hodgkin's lymphoma. Fast forward to today. A week ago, a jury in Georgia State Court found the pesticide manufacturer Bayer guilty of causing a man's non-Hodgkin's lymphoma after he had used Bayer's glyphosate-based weed killer Roundup. As I read this, I couldn't believe that even after 30 years after Emily's death, people are still being harmed and dying from this pesticide. Why doesn't the EPA put a cancer warning on the label? We have been fighting this battle for too long. Hundreds of thousands of children have died. As I think back to Emily, she would have been 44 years old this year, probably with a beautiful family of her own. She should have never died. With all of the evidence and documented proof of the dangers of pesticides that we've learned over these many years, it saddens me that we are still here. We are still fighting against this very real threat. We believe and we pray that you, our representatives, will stand and say no to House Bill 809. Thank you.
Thank you. Mr. Hensley?
Yep. Hello, Kevin Hensley, Tennessee Farm Bureau. There's been a lot said about crop protection products, and the concerns today have nothing to do with this amendment. Those in opposition to this bill have spoken about the topic to confuse this issue in order to make it seem like you, the members of the Tennessee House Judiciary Committee, are charged with determining if these products are safe. But that's not what this bill is about. According to Congress, through FIFRA, the sole authority to determine the safety of these products is the EPA. Even if this committee thought that that is what we were debating, the federal law preempts this idea. There is a process to address every single concern you have heard today through the EPA. So if that's not what we're discussing today, then what is it? This legislation, as amended, says the federal law suffices as a warning in Tennessee. What you are voting on is a simple question. In the Tennessee judicial system, should companies be liable for not putting a warning label on a product which the federal government prohibits them from doing? As amended, this legislation says the federal label is the law and that the companies which follow federal and state law have a defense against claims about following federal and state laws, which they must abide by. They have to do it to sell these products. This is not civil immunity. This bill is a defense for the manufacturers for which there is currently not a defense for. Our farmers must continue to have access to these products, and this legislation helps ensure that.
Very good. All right. Members, I don't have anyone on the list currently. Oh, I do. I have Representative Hardaway. Excuse me. You were underneath a piece of paper right there. You're hiding.
Thank you,
You're
Mr.
recognized.
Chairman. I thought I was going to have to go back there and have a conversation
I
with
was
Eldridge
convinced you were
again.
going to, so thank you for the reminder.
All right. Thank you. And I'm going to ask, I can't remember whether you're a lawyer or not, but I know you are. And my question is for these two, Mr. Chairman. The discussion seemed to be about the label and what was on the label and whether the federal government's labeling process is sufficient, or whether it's really the federal government has been deceived and there was fraud that was exacted upon the people, because the information for the federal government was not correct. So I'm going to ask that question of both of the lawyers, Mr. Chairman, whether there's a fraud element here that because of the way that I don't want to call the name of the company, but the way that the chemical company actually provided information to the federal government. He's been a little more aggressive. So
Tharp. I guess. No,
we can start here.
Hensley?
Yeah. So I think that the amendment addresses the fraud concerns. I would encourage you to read C on the amendment concerns, but I'm not a lawyer. And I know a lot about the FIFRA process, but I think that question may be more appropriate for Mr. Llewellyn. He is an expert on the FIFRA process and can explain that discussion probably a little more in depth.
Well, great. That's great. Mr. Llewellyn?
Yes, thank you. So yes, it is a requirement of the registrants not to deceive or hide any information. EPA has the ability within FIFRA to take action against those companies or registrants in how they wish in terms of be it civil monetary penalties or criminal cases through EPA and or through the Justice Department. So if anybody is breaking the law, then they're like any other person or any other individual or entity that breaks the law. They are subject to the penalties that come with that.
Oh, excuse me.
Andrew Tharp, Mr. Chairman.
Okay.
Yes, sir. Thank you. It's a good question, sir. I appreciate you asking it. The amendment, as referenced, actually says that if there's any fraud, concealment, or misrepresentation, this goes out the window. This no longer applies. There's no longer a protection.
President Hardaway?
So have you evaluated the relationship of the chemical company with EPA? Was there fraud?
I have not conducted an analysis of the relationship between any chemical companies and the EPA.
Has there been any such allegations in the courts?
That the chemical companies have
committed fraud?
I believe so. Yes, sir.
Yeah.
Any follow-up, Representative Hardaway? Or did you have a question for another?
Yeah, well, I can't remember who said what at this point. I was so mad at Eldridge. So someone spoke to, I think it was you, sir, that spoke to the three elements: design being inherent. Okay, design being the inherent danger that's produced by the design, then the defect, the manufacturing defect, and then the failure to warn. And you're saying that the only one that's impacted by the amendment and the bill is the failure to warn, and there's still the ability to bring civil suits under the other two. Okay. So is it unusual for there to be 2 out of 3 or 1 out of 3 or all 3 And how would the failure to warn impact the ability to bring suits based upon the design and the defect?
Mr. Tharp?
Yes, sir. Thank you, Mr. Chairman. So again, three primary causes of action under Tennessee product liability law. You have design defect, manufacturing defect, and warnings defect. This bill is written in a way where it clearly carves out only the third one when it says, for the purposes of a civil action commenced under a provision of state law concerning the duty to warn or label or any other common law duty to warn. It only addresses the third one. In fact, if you look at the Tennessee Product Liability Act, it says by definition, a product liability action includes all actions involving personal injury, death, or property damage caused by or resulting from, and then it lists a bunch of words. But those words all fall into one of the three categories. So it first talks about manufacturing defects. It uses the words manufacture, construction, preparation, assembly, and service. And then it talks about design defects, and it says design, formula, and testing. And lastly, it talks about warnings defects, which are warning, instruction, marketing, packaging, or labeling related to the product. So the three primary causes of action on a product liability case are design defect, manufacturing defect, and a warning defect. This only addresses warning defects. And a lot of the scenarios that we've talked about today and heard about here today really don't have anything to do with warning defects. We've heard some pretty scary scenarios about, little girls playing on a playground and then getting sick or becoming infertile. That scares me like crazy. I've got 4 daughters, and I don't want that to happen to anybody. But that has nothing to do with warnings. For that claim to be kicked, we'd have to be arguing that the plaintiff's counsel would advance a claim that the little girls were not appropriately warned. Obviously, that's not what we're talking about here. We're talking about a design defect. The plaintiff's lawyer in that case would be arguing that the product was inherently dangerous and could have been produced a different way or could have been formulated a different way. But the way that it was produced and the way that it was used, it was inherently dangerous and has nothing to do with the warnings or the labeling.
All right, members, here's where we're at. We're going to have to adjourn this committee today. So can I get a motion? But this isn't over. So can I get a motion to go back into session? Is there any objection to that? All right, seeing none. All right, members, hold 1 second, please. Please hold that. Chairman Doggett, you're recognized.
Thank you, Mr. Chairman. I know I'm out of order, but I want to recognize a couple of constituents, if I may.
All right.
I got Ms. Tess Robbins here with us today. And then Mr. Chester Morris II is with us today. If you would, please help me welcome them.
And here's the idea moving forward for everyone that's out there and for the members here on the committee. I'm going to ask the clerk and the speaker's office if we can have a special setting next week just for additional time, so we can ask the questions we need to ask. I'm going to allow for the folks that were up here to have some time to be fair, just like the folks that were there before. And then I'm going to ask that the folks that are on the list and get to come up here, I'm going to give them. We'd like to hear from them as well. So we need to take the time to hear from the folks that took the time of their day to be here. So I'm going to ask the clerk to set us at a special time, which will be announced on Thursday morning on the House floor, more than likely. So I just wanted to say that. Representative Towns, we need to get out of here. I got
Mr. Sam, we can get out of here. I just want to acknowledge my clerk that came in from Shelby County. He just came in just a moment ago. Clerk, if you don't mind, stand up, raise your hand there. Clerk Burgess, thank you for coming. He and the staff there. Thank you, sir. Chief.
All right, members, are we any objection to adjourning for today? All right. So and we're going to roll everything, including this bill and everything remaining to next week's calendar, including that special setting. Okay.